The Trump team and the Justice Department in court today with the special master actually pressing on Donald Trump's lawyers for evidence. NBC reporting that the judge was basically skeptical of the thrust of the Trump argument, pressing Trump's lawyers for refusing to substantiate Trump's claim that the declassified Mar-a-Lago documents somehow that there were declassification claims that could be supported. Indeed, the judge seemed doubtful of this entire defense, telling Trump's lawyers, you can't have your cake and eat it too. So there may be a bit of a rude awakening now that the special master is on the job. Again, you might have heard me say this if you follow our coverage. There was a procedural step that the Trump folks got, which did slow things down, and they wanted that. But procedure is not how you win. It's not how you get out of the clear. It just is a step, a process. And now that they have to deal with this actual judge and deal with a special master and deal with what is still a fact-based court system, well, you can see they're already having trouble. Then you have something going on in Florida where many of the courts lean conservative. You had a chaotic start. Bloomberg reported that many people who dialed in did not actually mute their phones. Bloomberg calling it a descent into chaos, although that might be a bit of a headline writer's overstatement. People were then screaming at people to mute, and then someone saying, God bless America. Today's hearing comes on the heels of Trump attorneys pushing back against, again, something the special master that they sought then demanded, which was, if you did declassify stuff, and again, that could be a valid defense if true, well, which things did you declassify? So is that a hard question to answer? Again, I'm not trying to give shade. If a president, as president, declassified a bunch of stuff, well, that's under the law a good defense. We could debate whether they should have, but legally you'd say, done, declassified. But if that's your defense and you can't tell us, or in this case, special master, that you requested, you can't tell them what you declassified, that defense is kind of evaporating in plain sight. Then you have this scuffle over the DOJ's review of these materials. There's an argument about whether the documents with classification markers, does that negate the privilege claims? Trump's arguments here are basically throwing a lot of different stuff at the wall. New York Times also reports that one White House lawyer, you might remember from the January 6 hearings, Eric Hirschman, warned Trump late last year that there could be legal liabilities, basically trying to help him and saying, in other words, just give the stuff back. Now, he was also on the inside when they were plotting various ranges of efforts to either stall the January 6th certification, overthrow the election, or even stage coups. So Hirschman, while not the most famous lawyer, you've got Barr, you've got Giuliani, he was one of the people in the White House counsel's office that we really only learned more about from those powerful hearings and his own testimony about pushing back.
What they were proposing, I thought was nuts. Flynn screamed at me that I was a quitter and everything, kept on standing up and turning around and screaming at me.
Let's get into it now with former federal prosecutor John Flannery. Welcome to the beat, sir.
Good to be with you.
Absolutely. I mentioned the procedure because while it is the type of law that is the most boring, I believe it's an important substantive distinction from did you steal documents? Did you lie to the government? Are you in trouble? That's all over here on substance, and they have not, and you tell me what you see, but they have not defeated any of those concerns yet, versus should there be a double check? Can you get to extra time? Can you pause certain things? They did, I would argue, procedurally get that ground. Now they're in court, and it's not going as well. What do you see?
I think they're probably saying, please don't throw me in that briar patch. But they wanted this judge. They wanted to have this matter before him. And he has a reputation, and I've never appeared before him, but he has a reputation in the Eastern District of New York as being by the book and not anyone's patsy, if you will. The motion that starts this whole thing is Rule 41G. You have two prongs to challenge a search. And it is one, there was an unlawful search and seizure. There's never been a credible claim of that here. And the other is that you want to return a property, presumably that you have some right to, like a passport, perhaps, that was mistakenly taken. I don't think they've solved either one of those, but Judge Cannon has opened up this whole thing. And the only thing that a special master would normally look at would probably be the attorney-client privilege materials, whether or not they were privileged. And that's difficult in some ways because if there's a crime ongoing, like having documents you're not entitled to have, that ongoing crime would make any, quote, alleged privilege evaporate. So that's the toughest question that you would have here. The second part is if you want this property back, it really had to be yours. And I don't know why lawyers have to say things like possessory interest, but Trump has no possessory interest. You know, we kill the language because we don't want to understand what's going on. So he's not entitled to that document that has to do with nuclear possibilities in some unknown foreign land that may compromise all manner of things, including national security.